Hello? Can you hear that? Testing? Oh no, I think. Is it working? Testing? Hello? Hello? All right, welcome. Okay, thank you so much for joining us. Welcome to Next Level Estate Planning, Adulting 101 for parents with minor children. I'm Jamie Daisy. I'm an adult services librarian here at the library. Before we begin, I have a couple of announcements. First is that the library now has an assistive listening system that patrons can use to hear better during events that take place on the library's main floor. The system filters the sound to emphasize the speaker's voices and transmits it to a receiver the patron can wear around their neck. These devices are available for today's program and are located at the table near the entrance. We ask that patrons wearing the receivers sit near the front of the event space, as the receivers work best when they are within fairly close range of the AV system, which is up here. We also have surveys today, so please, those are also at the entrance. Please complete a very brief survey after the program. It is available on paper, in large print, and on mobile device via QR code. And like I said, that's at the entrance. And now, I'm very happy to introduce Attorney Michelle-Shari Kruss. Michelle-Shari has been an attorney for 30 years and has specialized in assisting parents with their personalized estate planning. She manages her own law practice here in Lake Oswego and has served on the boards or as an active member of several local nonprofits, including the Friends of the Lake Oswego Library, and many more. So please help me welcome Michelle-Shari to Lake Oswego Public Library.
Thank you. Thank you, and happy Civil War games, I guess. So, totally missed that memo. But for many of you, you might be streaming online. And if you're streaming online, then hello. And if you're here, thank you for being here today. I'm trying to save the environment and decided not to bring any handouts. However, I'm going to be covering a wide range of topics. So if there's a topic that we talked about today that you're interested in receiving a non-obligatory memo about, I'm happy to send that to you. And what I'm going to do for everybody here or anybody that's watching virtually, and another time we should talk about digital assets and estate planning, it's a really good topic, then I'm going to go ahead and give you an 888 number. You can just say connect, and with that connect, you can go ahead and say, I really want to learn more about this, and I'd be happy to send you a memo on that and follow up with a call if you want, or just take it to your attorney and discuss it further with your own estate planning attorney. So that phone number is 888-414-9455. And we're trying it for the first time today. You just type in connect under text, and hopefully it will come through to me and just let's say, Michelle-Shari, I want to learn more about this, and I'm happy to send you a memo on any of the topics that I'm covering today. All right, so a little bit about me. As Jamie was kind enough to share, I've been practicing estate planning law for 30 years. I live here in Lake Oswego. I work here in Lake Oswego. I raise 2 children here in Lake Oswego. And what I want to do is I want to kind of blow away all of that when it comes to estate planning. I have so many clients that come to me sheepishly and they say, oh my God, we are in our 30s, we are in our early 40s, and our kids are now 10, 11, 12. We heard you speak years ago in our new moms group when the babies were first born and we never got around to estate planning. I tell them, you are doing just fine. And the reason I can say that is because in my 30 years of practice, my youngest client is 18. My current oldest client is 102. If you fit somewhere in between the two, you guys are rocking it, and it's a perfect time to do estate planning. And to also know that estate planning is not a static thing, right? You may have done some estate planning when your kids were little, but now they're a little bit older, and maybe some of the people that you appointed for some of these roles and responsibilities, they're a little bit older. And maybe you learned more about your kids and where they would be happiest living, and we'll talk about the choice of guardian and how you go about doing that. But maybe your estate also, besides your children and your family, have grown. Maybe you've got 14 cats. Maybe you have 4 dogs. Maybe you have 3 rentals. Maybe you have kids that live overseas. That's all great conversation. And if you have an estate planning attorney already, you should totally go back and say, hey, just want to fill you in on everything that's changed in my world since I first met with you. And if you haven't gone around to estate planning, kudos for you guys for being here today, because you should pat yourselves on the shoulder. You've adulted for the day. Woohoo! And you're going to walk away with some good, hopefully, information and feel a lot better about dipping your toe in the estate planning pool now that you can kind of have some terminology that you can use to talk to somebody if and when you're ready to do so. Okay? All right. Before I got started today, one of the guests that are here today asked me some really great questions that I'm going to blend in to today's conversation. I don't know if anybody else here has any specific driving questions that they want to chat about. Anybody? No? Okay. Anybody here? Who else here has minor children or kids under the age of 18? Anybody here have kids that are 18 to 25? Anybody here single? Okay. Well, we're going to talk a little bit about how this actually applies to everybody. Whether you have minor children, adult children that have children of their own, if you're single, if you're married, if you own property here, you own property over in another state, we're going to talk about that. And how we're going to go about talking about it is I'm known as the attorney that talks about estate planning being like a bicycle. Okay? Everybody's ridden a bicycle. Everybody's seen a bicycle. Just picture a bicycle in your brain. Bicycle has a front wheel usually and a back wheel unless you're riding a unicycle. You can ride a unicycle, we'll talk about that. But in general, everybody has an estate plan that has 2 wheels of their bicycle. A front wheel that says, what happens if I were to pass away or I and my spouse were to pass away? What are the documents that the state of Oregon might want us to have to make it as easy as possible to transfer our assets to another individual, to maybe if that individual is unable or unwilling to accept that asset, give it to somebody else. If we have minor children, oh my God forbid, who would raise our minor children? If we're leaving money to a child, do we give them money outright when our child is 18? Or do we have that money left in trust for them until maybe they're a little bit older? We live here in the state of Oregon, or I hope everybody that's watching this today and also here today are Oregon residents. And while Oregon is a gorgeous state, we unfortunately have an abysmally low amount of money that you can pass to somebody other than a U.S. citizen spouse tax-free. And that limit is $1 million, unless you do some sort of planning for your front wheel. Because if you do some sort of planning for your front wheel, then you're able to double it to $2 million. And people always ask me, they're like, well, is that $1 million per kid? Because they're thinking about gifting. I'm like, nope, it's $1 million that includes everything you own on date of death. And it doesn't matter if you leave it to one person or 50 people, it's just $1 million. So what you want to do is do a little bit of tax planning in one of your front wheel drafting documents. We'll talk about the different options that you have, and then be able to double that if you're married to a U.S. citizen spouse. If you're not married to a U.S. citizen spouse, please put in that connect and make a mention of that, and I'll send you a memo on that. If you have really large life insurance policies, ask me about that. I'd love to send you a memo on that, because there's some additional drafting tools that you can take advantage to try to mitigate the Oregon estate death tax when you have larger life insurance policies. So again, why do we do front wheel drafting? Is because we know that if we, God forbid, were to pass away, then there are certain documentation that the courts are going to need to know what are the things that we own, who do we want to give it to, when do we want them to receive those things, and do we have a backup plan if those individuals are unable or unwilling to accept those items. Okay, that's the front wheel. The back wheel of your estate planning bicycle, which is honestly the wheel that I want everybody to start on first, only because that is what I see most as part of my practice. The back wheel says, I'm going to live forever. And I hope to God all of you do live forever. My clients seem to do so. So we're going to have this conversation, 30 years of practice. I've had very few of my clients pass away. But these incapacitation documents, these documents that would allow you to choose somebody for you to stand in your shoes to make a medical decision, a financial decision, transmit medical records electronically, deal with a digital asset, or your child is a minor but can be by themselves for the day, if that minor child needs to be medically evaluated or treated and you're unavailable or your cell phone is off or you're hiking and you just don't have really great cell phone reception, if you want to arrange for the medical care of a minor child and you're unavailable to take that call, you can name somebody called a temporary guardian to address the medical care of a minor child for a non-life-threatening condition, even if they can't get a hold of you. So there are 5 documents that make up the back wheel incapacity wheel, and those are the ones that I desperately hope everybody here and everybody virtually will consider starting with, because that's what I see the most of. So let's kind of pick those apart a little bit. 2 of them are medical documents. The first one's called a Physician Advance Directive, and the second medical one is called a HIPAA. The Physician Advance Directive is a document that says, if I want somebody to stand in my shoes to make a medical decision, have doctors talk to one another, authorize a medical procedure, this is the document that I'm going to need to complete. That document, it requires you to sign it in the presence of either a notary or 2 witnesses and get your healthcare agents to sign agreeing to be that person for you. A lot of people come to see me like, oh, shoot, I have one of those. I had an elective procedure at the hospital, and I signed one of those. I'm sure the hospital's keeping a copy of it. But the thing is, the hospital doesn't keep a copy of it. So it's a good idea for you to have your own copy that you store. Now, that's a good thing. We don't usually talk about that, but where do these documents live once they're done? So many people sign them, and they can't find them, right? Or they sign them, and they put them in a drawer somewhere in their house. And while I think that's brilliant, that you would sign them and maybe put them in a drawer somewhere in your house, what happens if you have an incapacity and you're not home and someone needs to actually access those documents? How are they going to go about doing that if they can't get into your house? Or other people say, you know what, I've done those documents, they're in my fireproof safe. Again, brilliant, but if you need them, who's going to have access to those documents straight away? So what I always recommend that you do is you scan those documents, not all together, but individually, and you hold them somewhere on the cloud with a downloadable option that if you're traveling or if you need somebody else's help, they can log in as you and go ahead and get access to those documents and forward it to the entities that are requesting it. So with Physician Advance Directive, I think it's a good idea for you to sign it and then also do this document called a HIPAA, which allows those same people to be able to transmit medical records electronically, scan them together, and make sure your primary care physician has both those documents, whoever you named as your healthcare agent has copies of both those documents, and maybe store a couple of sets on the cloud just in case you're traveling. If you need to use those documents, they will be readily available. Okay. A lot of times people will have one, not both the documents, or they have the documents, but they have them for a limited purpose, meaning for a specific hospital or a specific network or a specific medical situation. It's a really good idea to have some global ones. Okay? Those are the 2 medical. The third document is called a durable power of attorney for finances, or a financial power of attorney. And that's one that I see very often, especially with older individuals, where their kids were young and they wouldn't think about naming their kids because their kids were young at the time, but they just name each other. And my concern with that is what happens if you're both incapacitated at the same time? Or maybe you're this much older and maybe there's a memory issue. Or maybe you're incapacitated but your significant other is overwhelmed and doesn't want to be the person to activate that power of attorney because they need to fight with an insurance company or put a fraud alert on a credit card or replace a passport or log in as you somewhere on the internet or close down a retirement account that's only in your name or deal with a home that's only in one person's name, or you're in the middle of refinancing or buying and being able to sign those electronic documents. It's always a good idea to have a backup person. And for younger individuals, sometimes what they'll do is they'll name their parents as those backup people. And that's absolutely cool. You can do that. But I think it's a good idea to maybe put an age limit on them serving. Say, I choose my dad as long as my dad is under the age of 80. If he's 80 or better, I choose my mom. If not my mom, then I choose somebody different. Not all durable power of attorneys are equal. So some of them are very succinct and cover very few things. Some of them are a lot more elaborate. I think it's a good idea if you do a DPOA to make sure it covers all the hypotheticals that I think it should cover. So if you want a summary on what should be included in a durable power of attorney for finances, or you want to schedule a courtesy half an hour, I'm more than happy to talk to you about the durable power of attorney for finances that you signed, who you named, what maybe should be included, what was included that maybe shouldn't be there actually, and was it actually signed correctly, and where should that document live once it's done. With the durable power of attorney for finances, one of the things that Oregon does is we address digital assets, meaning addressing where you live anywhere on the World Wide Web, because we live more virtually than we tend to live physically. Think about it. You probably have done a telemed appointment. You probably have computers. Obviously, those of you who are watching me online have computers. Maybe you use Zoom. Maybe you have a cell phone. If you do, you have a digital presence. And if you have a digital presence, you want to make sure to address that both in the incapacity back wheel drafting, but also the front wheel saying what happens if you were to pass away. So working on something called a digital asset worksheet's not a bad idea. I mean, I gave a class at the Lake Oswego Adult Community Center once to a group of average age in that room were 82. And they're like, yeah, digital assets, that's not their thing. They don't live virtually. So normally when I give a class specifically on digital assets, I'll say stand up, sit down if I name an asset where you might live on the World Wide Web. But instead for this group, I asked them to hold out their hands wide and put down a finger each time I named a place that they might live on the World Wide Web. And by the end of my list, all hands were closed. Because we do live more virtually than we do physically. And as such, you would want to make sure that if something were to happen and you need somebody to be able to log in as you, stand in your shoes to address somewhere you live on the World Wide Web, big deal that had happened during COVID, where like wire transfers gone AWOL, things like that come up, you want to make sure to address digital assets in your estate planning. So that's the fourth document. The fifth document is for parents that have minor kids. And it's like babysitting instructions on steroids. And you can have as many of these temporary guardianship affidavits in existence at one time. You've probably completed something like that for school. And you've said, if I can't pick up my kid from school, then I trust this other person to pick them up from school. Brilliant. It would be a really good idea to have a temporary guardianship affidavit that's available all the time. The key with the temporary guardianship affidavit, though, and then for those of you who have minor children, I'm going to email one to you today, is that it lasts as short as a day or as long as 6 months, never longer than 6 months. So you could name me as a potential temporary guardian, maybe because I'm taking your daughter overnight to Seattle to see a game. But you might have another one that lasts up to 6 months because you named Nana and Papa because they live locally and they periodically babysit. You could do another one because your sister and brother-in-law are coming in to visit, and then you and your husband are going to maybe go away to the coast for the weekend, and you just want to make sure if a child needs to be medically evaluated or treated, they would have that legal authority. So the temporary guardianship affidavit is that fifth document. If you're a grandparent and you're watching minor children, then that's a great document for you to have as well. It's just you wouldn't sign it. It would be the biological parent of that minor child that would sign it, giving you that authority. So these 5 documents. I think if you have nothing in place at all, that is an amazing place to start, is with those back wheel incapacity documents, one or more of them. If you did those documents more than 3 years ago, it's a really good idea to have somebody take a peek at those documents again. Because some of those documents are considered to go stale after a decade, and many of them have changed dramatically in the last couple of years. So having somebody maybe spruce them up a little bit wouldn't be a bad idea. All right, are there any questions so far? You guys are doing great. I know it's warm outside, it's Saturday, you'd really rather watch the game, but I promise you, if you have a little bit of time and you let this settle a little bit or rewatch this video that'll be on the Lake Oswego website, I think that you'll feel comfortable moving forward in some sort of way, whatever's best for your family. So those are the back wheel incapacity documents. The front wheel says, what happens if I pass away? Well, when you pass away, those back wheel incapacity documents, they go away. Now we're looking at the front wheel. And the front wheel, you really have 3 options. And I was going over that with one of our patrons right before this class. Okay. Option number 1 is to do no planning at all. I do not recommend it. It's what's called passing away intestate, with no plan in place. And if you pass away with no plan in place, the state of Oregon will create a plan for you, whether you want one or not, based on the Oregon revised statutes. It takes a long time. It costs money. You don't get to make determinations. You don't get to take advantage of planning tools that you had available. I know a lot of people just kind of kick the can and say, I'll get to it when I get to it. I'm young. I'm healthy. I don't need that. Unfortunately, for part of my practice, what I do see, unfortunately, are a lot of people that come to see me because they're in the midst of an emergency. Somebody has been diagnosed unexpectedly with a life-changing disease. Somebody passed away unexpectedly in an accident or because of a disease, and now they're in frantic mode saying, oh, now we need these documents. This is the worst time to do drafting. You want to do it when you have a little bit more time to be thoughtful about it. You want to do it when you can sign things more easily. Getting somebody to go, a notary to come into ICU to sign those documents for you on the fly is a tough call. When so many of my clients, I don't know why, seem to get sick around Thanksgiving or Christmas. And finding an estate planning attorney willing to respond to you the week of Christmas and do drafting very, very quickly for you. And I had 4 clients that were end of life that reached out to me just this last December. When that happens, it's really tough to find somebody who has the bandwidth to take on somebody new. But it's also really tough for you to have to make some of these decisions when really your attention should be elsewhere. So please, even if you're not ready to do any estate planning at all, find an attorney. And again, it does not have to be me. This is not like a Tupperware party where you're walking away with a piece of an estate planning attorney. And by the way, disclaimer, this doesn't include become an attorney-client relationship, right? I'm just giving you some general information that I'm hoping that you will build on to go back to whoever you have as your legal guide to continue that conversation, or give me a call and I'm happy to chat with you. But I'm hoping at least you're starting to build some resources so that when you are ready, you feel comfortable moving forward. I mean, the goal today is for you just to go, I was really stressed out about this. Seems like an awful lot. I really don't understand this. I really just need somebody to break it down for me in simpler terms, in ways that we can understand it, and not make us feel like we have to do everything all at once, because you don't. You can start very simply with just the back wheel. Then we can build the front wheel, and we can pick apart each of these planning tools for you based on where your family is, what your assets are, what you're hoping to accomplish, and we can have a 5-year plan, a 10-year plan, a lifetime plan. So just try to find somebody you feel comfortable having that conversation with. And if you'd like me to give you referrals for other people, other attorneys here in town, I'm more than happy to do that. So again, coming back to the front wheel, doing nothing at all is just really not in your best interest, your estate best interest, or your family's best interest. So are there 2 other things that you could do that would be better? Yeah. You can do a will, and within a will, as we were talking about, you can have various trusts within your will, and you can do something called a revocable trust, something a little bit different. It also can have similar trusts within it. So what are the type of trusts that maybe you would have within a will? Well, maybe some of you that are watching are married to non-U.S. citizens. So if you're married to a non-U.S. citizen, there's a tax planning tool that we can utilize to try to mitigate the Oregon estate death tax on the death of the first spouse. Maybe, remember we talked about this at the beginning of the class, maybe you have a taxable estate, meaning you have an estate that's worth more than $1 million. Maybe we should do some planning that would mitigate that Oregon estate death tax. Maybe you have pets that you want to take care of, and maybe you want to set up something called a pet trust. Maybe you have a child that has special needs, and that maybe we should look at doing a special needs trust. Maybe you have perfectly healthy children, but they're young, and you don't want them to receive their money outright now, or maybe at 18. Maybe you'd like them to receive the money when they're a little bit older, maybe 25 or 30 or never. And if so, we could do some planning for that too. All that type of planning can be done within a will. You could also do similar type planning, something called a revocable trust. So then, why is it if you can do relatively similar planning in a will versus a revocable trust, why do some people rely upon a will? And why is it that sometimes people advocate for a revocable trust? And as I was explaining earlier, with a will, the first thing that happens on the death of an individual is if you have any assets that are owned jointly with somebody else or has a beneficiary designation, so held jointly with somebody else as joint tenancy with right of survivorship, so has survivorship provisions, then when you pass away, those assets go to those individuals. So if you own a home and you're entitled to that home with somebody else and you own it joint tenancy or tenancy by the entirety, if the first spouse passes away, then the other spouse takes the house. If you have life insurance, retirement, checking accounts, if you're the only person on title and you named a specific person as a beneficiary and some contingent beneficiaries, then that's where that asset's going to go. But what happens if that asset was going to go, let's say, to your children, but your children are minors? That's where we rely upon the will. And the will says, look, I do want to give that money to my children. I just don't want to give it to them now. I want them to have it, have access to it, but I want somebody to manage that money for them until they're a little bit older and kind of have some oversight as to what the money is being used for. So if our children's guardians need to use that money to raise our children, absolutely that money is going to be made available. It just is going to be dispersed by maybe somebody different than that child's guardian. And we'll talk about guardianship, called a trustee. So with those assets that you did have beneficiary designations for, brilliant, but you might have specified that instead of it going outright to the children, instead it would go into their trust. And if it goes into their trust, then somebody would need to look to that will and say, oh, they set up this trust. The trust says that the money maybe is in a pot trust for both kids until they're 18. When the oldest kid turns 18, it's divided into a separate share trust. The trusts continue as separate share trusts until the kids are like 26. At the age of 26, we start to give them outright distributions, maybe the interest that their trust has earned on their 26th, 27th, and 28th birthday. And when they turn 28, they get whatever's left over. If a child passes away before the age of 28, we even have a contingency plan for that. That says if a child passes away before the age of 28 and they have children of their own, maybe the money continues in trust for that child's children, your grandchildren. If they don't have children of their own, maybe you give it to the other child and add it to their trust. And all that language can be within the will. If you want to do tax planning, then instead of that spouse automatically taking that money upon the passing of the first spouse, they might want to activate the tax planning. That could be in the will. But inevitably, even if you own things jointly with somebody else, and even if you have a beneficiary designation for almost everything that you think you have, it kind of begs the question is that what happens if that person is no longer alive and can't receive it? Or decides not to receive the money at all? Or you forgot, you set up a checking account and oh my God, you set it up in your name, you rush to do it to get the advantage of that higher interest rate, and you never put down a beneficiary designation. Now we have an asset out there that the courts are like, well, this person passed away. We have no idea who to give this asset to. So what are we going to do about that? Well, if you passed away intestate, remember option number 1, the state of Oregon would look at the Oregon revised statute and would look it up and say, oh, well, it says it should go to this person, but a probate would have to be open for that person to receive it. If you pass away with option number 2, which is a will, and you have no beneficiary designation, then this person called a personal representative would submit a copy of the will and say, oh my God, mea culpa. It turns out that they wanted to leave it to their niece in Arkansas. And the courts would give them a permission slip to be able to do that. And then the personal representative would be able to disperse that money to the niece in Arkansas because you left an asset that didn't have a beneficiary designation on it. Also within the will, we do guardianship. Guardianship, I love. So again, I'm all about imagery. Whenever I lecture for schools, which I do often, or specifically for parents with minor kids, where I'm allowed to bring food, I always bring cookies. Usually an Oreo, I can't do trademark, but an Oreo type cookie that has a top, a middle, and a bottom. Okay, so if you could visualize the Oreo cookie like you visualize the bicycle, that would be great. So what's the top of the Oreo cookie? If you were to pass away and your spouse couldn't become guardian, the question becomes, who would you want your child or children to live with until they're 18 years of age? And let's say that I was your sister, and you're like, oh my gosh, absolutely, I would name Michelle-Shari as a potential guardian. I would say, are you naming just me, or are you naming me and my husband? And you said, hadn't really thought about that. I said, well, God, if something happened to me after becoming your child's guardian and your child or children were living with us, would it be okay if my husband continued on as that guardian? And you're like, I don't know. I said, okay. So what we could do is we could say, I name Michelle-Shari and or her husband, jointly or individually, to be guardian. That's the top of the Oreo cookie. If they get divorced or separated, I choose just Michelle-Shari because we're siblings. But if something happened and Michelle-Shari wasn't able to become or continue as guardian, leaving just her husband, you could say option number 1, no way, no how. Option number 2, absolutely, he's a gem of an individual. Or option number 3, I want to go to the bottom of the Oreo cookie. And the bottom of the Oreo cookie is something called a guardianship panel. And it's a panel made up of family members or friends of your choosing that would come together at that time to evaluate the situation. Because sometimes I have clients that come to see me and they have 3 kids. And they're like, oh my God, we can only choose a potential guardian that can raise these 3 children. But there's a possibility they're not triplets, that 2 of your kids are over the age of 18, are already in university, and it's actually the youngest kid that's the only one that needs guardianship. And maybe somebody you would never have chosen as a potential guardian because they live in another state would absolutely be a perfect person as a potential guardian because both of those kids now live in Washington State. Maybe they attend a school like UW, and your youngest kid wants to live closer to the 2 older children. Who do we put on the guardianship panel? Probably your potential guardian choices and your kids. So option number 1 is you could say I name Steve and Michelle-Shari jointly or individually be guardian. But if they get divorced or separated, then Michelle-Shari. If it's just her husband, then we want to go to the guardianship panel. Option number 2 is you could say, however, if both of our children are 10 years of age or better, instead of automatically going to the top of the Oreo cookie, we want to go straight to the guardianship panel. And we want to put the kids on the panel. We want to put Michelle-Shari and her husband on the panel. We want to put our 4 close personal friends on the panel. And we want them to choose at that time the potential guardian. And you can tell them who they can choose from and why. You could say they could choose this particular couple if they still live in the Pacific Northwest. You can choose this particular couple if they're under the age of 80. You can choose this particular couple if we have more than 1 kid that's under the age of 18. So if that's the bottom of your Oreo cookie and the top of your Oreo cookie is that first choice that you like, what's the middle of the Oreo cookie? And the middle of the Oreo cookie is what I call a temporary guardian. It says there may be a chance that your permanent guardians can't come collect your kids straight away. Maybe we have a winter storm. Maybe they live in another state. Maybe they're traveling at the time. You want somebody that lives locally that can pick up your kids straight away and hold on to them for however long as possible. So, for example, let's say your permanent guardians live in Vancouver, Washington, hypothetically, but you live here in Lake Oswego. Maybe you have somebody here in LO that can be a temporary guardian that can let your kids finish up the school year. And once it's the end of the school year, then transition them someplace else might be a great thing, a good option to have. So even if your permanent guardians live on your same block or in your same city, I think it's a great idea to name a temporary guardian. But I also think if you're a parent, you might want to explore a little bit more about that Oreo cookie and take advantage of maybe allowing your kids to have some say as to where they want to go or to reevaluate the situation at that time. Questions so far? No? Okay. Well, I don't know if there's any questions online, but you'll let me know because you'll send me an email. Okay. So again, there's lots of great planning that you can do within a will. Those similar plannings you can do in a revocable trust. The big reasons that you might want to think about doing a revocable trust, perhaps, instead of a will, is something called probate. And the reason is if you can think of a revocable trust, think of it maybe like a bucket. And during your lifetime, you're putting all your assets into the bucket. So much so that if you became incapacitated or passed away, this person called a trustee would have the access to the things within the bucket and would be able to deal with them straight away. When you have a will, You can rely upon your back wheel incapacity documents if you're alive but incapacitated and need somebody to help you. But there's sometimes a delay with using those incapacity documents because you have to find it, you have to submit it for approval. Many times when you do a revocable trust, by contrast, when you set up that financial account, you gave them some sort of indication that that asset was going to be titled in the name of the bucket by giving them some paperwork to make that so. And as such, they already have that on file. So if you become incapacitated or passed away, this person called a trustee acts as you and is able to address that asset straight away. So where I see it a lot is with homes, right? Inevitably, somebody might come into this relationship with a house from before they were married, and they want to keep that house only in their name. And they want to let their surviving spouse live in that house if they were to pass away, but they don't actually want to give them the house. They want to give them use of the house, but not permanently to keep the house. And they want to say if that house, if they get remarried or if their kids are out of school and they want the house sold, they want the house then to go to somebody else. A revocable trust is a much better vehicle for that because you can give that surviving spouse something called a life estate, meaning an opportunity to use that piece of property for a period of time. And then when they no longer need it or a certain period of time has come up or they passed away or your kids moved out of college, then you could have that house sold and the proceeds added to, let's say, the kids' trust and use it for education, hypothetically. So sometimes I have people that own homes that are just in one individual name. Sometimes they own homes as what's called tenancy in common instead of with survivorship. And as such, you own just that 50% portion of the house. And if you only own that 50% portion of the house and you were to pass away, that house would have to go through that retitling probate process because technically you're the only owner of that 50%. But if that 50% was in the revocable trust, then the trustee becomes the owner of that 50% and can deal with that particular piece of property. If you own property in multiple states, it's a very, very good idea to consider doing a revocable trust because then you could avoid probate in those multiple states. If you have a complicated estate or maybe you're a blended family, meaning that one or both of you came into this relationship with children from outside this union, more often a revocable trust is a better vehicle for that. If you want privacy, a revocable trust is a more appropriate vehicle than a will. But just because of these things, I don't think you should automatically say, I need this. I think, again, and that's not my purpose today, to convince you one way or another whether it's a good idea to do a will or a revocable trust. I just think that you should schedule an appointment with somebody and just lay it on the line and say, you know what, these are the assets that we have. This is how they're titled. This is who we want to receive those assets. This is when we want them to receive these assets. Explain to me if I choose option number 1 and I pass away with no plan in place, what does that look like? Option number 2, with a will, with whatever trust you recommend, what does that look like? And if I do a revocable trust, what does that look like? But don't go into it saying, I need this. Because you might have your mind blown and realize, wow, I didn't realize, because there's a lot of other planning tools that are available to you, like TODDs, transfer and death certificates. There's lots of great options or titling of assets. Maybe make that appointment and think about your estate planning. Think about yourselves as being like kings and queens of this kingdom, right? You're the king and queen, and you just need knights around your round table. And maybe that means it will be your CPA and your financial advisor and your estate planning attorney. Just make sure they all talk with one another and make sure everything's one big cohesive package. Because if something happens and you become incapacitated, your non-incapacitated spouse is really going to rely on those knights to make sure everything remains protected. And what you don't want to do, and I see this very, very often, where somebody will take the helm. It's usually the husband will take the helm and they will find those advisors. But I beg of you to find advisors that both of you can speak to. Both of you feel comfortable having those conversations. Because if you, as the spouse that establish that relationship, becomes incapacitated, you want to make sure that that non-incapacitated spouse feels comfortable, especially because they're coming up from the back end, to be able to ask the questions and get that clarification, get that guidance that they need, and not feel awkward about doing so. Okay? So estate planning 101, please consider starting with that back wheel. It's a brilliant place to start. Make sure you have one or all of those 5 incapacity documents. Once you're done with that and you're like, okay, then maybe pivot to talk about the front wheel and meet with somebody to discuss what is it that we've done, Was it done a while ago? Are our wishes still the same? Are the people that we name for some of these roles and responsibilities, whether it's a personal representative, the guardianship cookie, Oreo cookie, the trustee, are those still the best people for those jobs? Do we have kids that have special needs or we want to have special opportunities for? Do we own assets that are different than the assets that we owned when we first did our estate planning? Did we make sure to coordinate our financial accounts with our current estate plan so they mirror one another and they're not in conflict with one another? Did we have additional children? Have we gotten divorced or remarried? Those are all great opportunities to meet with somebody. So hopefully today you'll be able to go back and look at your documents and say, do I have some of these documents? I'd be happy, as I said, to send you a checklist of all these documents. If you are and you're locked in and solid, please maybe consider talking to your parents and make sure they have their planning in place. Because this is a great opportunity, especially for my sandwich generation, where my clients have children of their own, but now their parents are starting to rely upon them, to maybe having a conversation with them and discuss with them, where are your documents? When did you sign them? Who are your advisors? Who did you name? Are those still the people you want to name? Do you still own those assets? If you don't own those assets, is this really the best planning vehicle for you? So I think all of these are great opportunities for you to just take a breath, take a look at those documents, but please don't be that client that calls an attorney in the midnight hour on a Sunday night or right before Thanksgiving or right before Christmas and say, oh my God, I need this because of this. And a lot of times clients will wait till the end of the year because it's wintertime, their kids are a little bit older now, they're traveling maybe on vacation without their kids, they're leaving their kids with grandma and grandpa, they want to make sure they have some insurances in place. Sometimes, unfortunately, people get some not great news about medical situations, and they're like, before things get worse, I just want to make sure that I've got this locked down. Again, this is a great opportunity. The beginning of fall is a great opportunity to at least start exploring some of these topics and to meet with somebody to have a further conversation. So, I thank everybody for being here today. For those of you that came despite the Civil War games, thank you so much. For those of you that were watching this later, thank you. For the Lake Oswego Library, a huge amount of appreciation. And otherwise, have a really great and wonderful fall and an even better end of the year. Thank you so much.
Thank you so much to Michelle-Shari, and thank you, of course, for attending, and to our volunteers, Allison, Gia, and Jonathan. And we hope to see you again soon. Thank you.